I imagine most of you are familiar with Illuminati, the evil, awful bitch of YouTube who basically went mega viral in the worst way possible after it came out that she had basically just outright abused, actually. I'm not going to say basically, just outright abused her former employees slash work partners in a group called Sad Milk. One of those people being her ex-partner. And since then, she is engaged in harassment campaigns, slander, stalking, and most recently, heavy litigious behavior towards her victims who have dared to speak out and make their experiences known. One such person is Oz Media, who may be getting it the worst because he is, of course, I believe the not ex-fiance, ex-boyfriend of Illuminati, and she is going after him hard. Now, when I first covered the Oz Media video that came out recently, Dear Illuminati, this one right here, I had pretty optimistic perspective. Like, Oz Media was raising a good amount of money, and it seemed like it was really clear that what Illuminati was doing was a, like, open and shut Slapsuit, right? Like a very easy case to just say, okay, yeah, no, throw that out. The judge is just going to do that, right? Well, turns out we would be wrong about that because things have not gone in the direction that you would either bet or hope, and that it seems the judge is somewhat favorable, worryingly so, towards Illuminati. Xander Hall, money helps change the law in your favor. That is to some extent true, but at the same time, like, the judge is still supposed to not uphold a case like this that is so obviously a slapsuit. No what? No, yeah, it's not good, guys. Of all the cases, it seems the judge does not understand the internet or YouTube and may genuinely side with Illuminati on this one, regardless of legal defense. It is so hard for good people who are on the right side of things to win cases that involve the internet. One of her trolls is fucking with Oz. Yeah, I saw this. Is this the chargeback thing? Yeah. This is so fucked up. This is my block add-on being, like, glitchy and outdated. This is a bug here. Someone is trying to charge back $3,000 they donated during legal fundraising, and I have no idea what to do, as it was from 5 days ago, and I already used said funds to cover my legal invoices. Like, what the fuck do I do? Like, bro, don't donate large amounts and do a chargeback. Currently disputing. This user has been banned from donating in the future. Dick move to do during a legal fees fundraising stream. Jesus Christ. Yeah. People do that. Chargebacks, it's a really common thing, and I never really, like, assume I have as much money as my accounts say, because someone could charge me back for, like, you know, a pretty decent amount of donations if they donate a lot to me, and, you know, I could have spent all but that amount of money, and then all of a sudden I've got nothing, you know? Like, you gotta be careful, right? Anyway, apparently, this guy, Mad Catster, did a good video breaking down the updates on the lawsuit that have come out over the last, since we got an update from Oz. And people in my Discord are recommending we watch this one, so we'll check it out. We got quite the character here who it seems is going to be explaining this to us, so let's watch.
Hey there, I'm the Mad Capster. I'm glad to see you here. Well, the court has finally ruled on the 2 pending motions to dismiss in the Illuminati lawsuit. It's kind of a mess. It's not as clear-cut and as neat as I would have liked to have seen. We're going to talk about what the judge has done. I've got copies of both the decisions because you know me. I've got the deets and all the receipts, and I've also got Cedric being a pain today. So buckle up and let's go.
Cats.
So welcome, you guys.
I do like the cats.
We have passed the 50,000 subscriber mark. We're actually almost at 51,000 subscribers. Can you believe it? Thank you guys so much for getting us here.
Yeah.
And also, if you're not subscribed, please like and subscribe to the video. We're going to talk
50k subs is a fun sub count. Like, I actually think 50k subs is more fun than 60k subs, and I don't know how to explain it, you know? It's just like, hitting 50k is such a milestone, you know? It's like, holy fuck, I am halfway to 100k, you know? Like, I am so a YouTuber now, you know? And then, of course, 75K is a pretty good feeling, too, because you're 3/4 of the way there. You know, you're in the final stretch. 90K will probably be the next best feeling before 100K. And we're getting there. We're getting there. I'm less than 3,000 subs away from 90K. And then it's just the final 10K stretch to 100,000 and that silver play button. I'll probably put it up like right there next to the flag. I don't want my head to block it though. I don't know. We'll figure out the camera orientation for the setup. The neat thing about a proper DSLR camera, which I'll buy for the Quail Arc, is it's going to have a way wider field of view within the same pixel count, if that makes sense. It's going to be a higher pixel count, which means within the same aspect ratio, there's going to be a larger field of view. And so you're actually going to be able to see like a bit to here and a bit to here, which means way more of my room will be visible and I can be a little more creative, and the vision, like the picture will be clearer. It's one of the benefits of having like a proper DSLR camera is you can set that shit to a nice wide field of view and retain so much detail and not really fuck with your aspect ratio. It wouldn't really affect like how much space I'm taking up here on the screen.
Talk about now the two decisions that came down from the judge in the Illuminati lawsuit. It's really a mess.
I love this channel, this cat themed law channel. This is a good, I like this this niche. This is a small but absolutely filled niche.
And I'm going to explain to you my opinion on some of what the judge had to say. It's sort of a good news, bad news kind of scenario. And we're just going to go over, the decisions aren't that long. We're just going to go over both of them. And I'll give you my opinion whether I agree with the judge or not on some of the things he said. So let's get into it. I'm sure you've all heard of data brokers where companies like take all your personal information and sell it to various people from spammers.
I won't skip the sponsor because we're watching his video, you know. We're not gonna skip the sponsor. We're gonna be good, kind, courteous reactors and watch the sponsor bit.
To scammers to who knows who. So I started to myself and I was shocked at how many of these data broker companies exist. They get your full name, your address history, your court records, your phone numbers, your family members, and all of this information they make available to whoever pays for it. That's why I've been using Aura, the sponsor of today's video, and I would like to thank Aura so much for sponsoring this video. And I have been trying it out. I had looked, when they approached me, I looked them up, and Forbes magazine gives them an excellent rating, and I've been using it, but I'm really impressed with the wide variety of things that it does, and also they have a really great app that you can use as well. And one of the features of Aura is they will show you which data brokers are selling your information, but you can have them have you opted out of.
It seems like a lot of these like services are sponsoring YouTubers lately. This is the second one today.
These services, and Aura takes care of all of it. I tried it out. It's really great. It's so easy. It not only reduces the amount of spam that I'll get, but it also protects me from hackers who want this sensitive information. I feel really confident now that Aura is taking care of that for me. If you saw it, but recently AT&T revealed that like the information of over 73 million people they had in their databases got released on the dark web. I mean, how frightening is that? AT&T recommended that people who might have been affected, that they use stronger passwords, they monitor.
It would be an orange cat getting all up in the camera, blocking it with its butt.
Account activity, and that they put either a freeze on their credit reports or fraud alerts with the credit bureaus.
It's always the orange one.
What's really awesome, again, is Aura takes care of that for you. You don't have to deal with different apps and different websites in order to accomplish that. My information has been compromised from AT&T. I know I don't have to worry because Aura is going to keep me safe and take care of it. I value my privacy. I'm sure you do too. I feel secure with Aura, and I want you to feel secure with Aura too. They will give you a 2-week free trial. You can check out Aura and see how great it is. You go to Aura, aura.com/madcatster. I'm also going to put the link down below in the description that you can click. You should check them out and use that link.
Vosh's cats are legitimately the nicest cats I've ever met. And I've not met a lot of cats, to be fair, but I've seen a lot of videos of cats, and like Vosh's cats are about as nice as it gets when it comes to house cats. Like all of them are. Like, maybe not with each other. Like, they definitely bap each other, I imagine. But, like, even with guests, you know, like, I met those cats for the first time. And Artemy is, like, so friendly. He just lays on you. He's just, like, a big ball of fluff and fat and meat. And, like, he kind of feels like if you got a big gallon-sized Ziploc bag, filled it with mashed potatoes, chicken bones, and, like, fur, and then just like flumped that on your chest. But then did that 3 times because he's about 3 times as heavy as that. That's what he feels like. And he just kind of lays there. He's very friendly. He's very soft. All the cats are very soft. Very nice cats. Very fun to meet them. Ew, what an image. I mean, it's the best way to describe what the cats are like. I mod for a guy who has an orange cat had an orange cat jump on him from the rafters while he was streaming. They're so fucking funny, dude. Orange cats. It's always an orange one.
It's on the screen here, and it's down in the description, and I know that you'll be as happy as I am with Aura. So the first decision that we have, we'll talk about, concerns Oz Media's motion to dismiss. Now, you remember the court has allowed Blair, the Illuminati, to amend her complaint, so she had a complaint, an amended complaint, and a second amended complaint. Something else comes up in this that really irks me. We'll talk about it in a minute. And then Oz basically had to do 2 motions to dismiss because once she got permission to amend her complaint, again, that motion that he first filed was no longer relevant. So let's take a look first at this Oz Media motion to dismiss decision. And it's, Pyramid Entertainment versus Oz Media, and there's the other defendants. And here's the order regarding the motion to dismiss. It says, before the court is a motion filed by defendant Oz seeking dismissal pursuant to the rules of civil procedure and the Anti-SLAPP statute of plaintiff's claims against him in the second amended complaint. I've previously allowed 2 amendments of the complaint, following which Oz renewed his motion to dismiss. I've reviewed the renewed motion, the response, the reply, along with the case file and applicable law. So remember, he filed the motion, she filed her response to that, and then he filed a reply, and we've covered all 3 of those different pleading. If you haven't seen my other videos on Illuminati, go.
To give you an idea on how much power the judge has to have ended this already, by the way, do you want to know what happened when I got slap-suited of sorts? There was a crazy-ass bitch who tried to sue me, not for defamation. Well, no, I think she did, actually. But I think that was part of it. But she did a temporary restraining order and tried to file for a permanent restraining order. For which, for those of you guys that don't know, that would, ban me from owning guns and stuff if that went through. So, she was actually trying to, severely hurt my life with that. Yeah, that is who it was, Circuit Dog. And, the judge threw out the case. The judge saw that, we had never had real-life contact, and I had never contacted her before. And B, she was searching for protection for her cat, I think it was, who was Mr. Whiskers or something. It was a pretty funny name. It was a pretty adorable name for a cat, to be fair. Who's Sasha? Crazy lady who hated Keffels a lot, but unfortunately for her had also had multiple pretty credible accusations of sexual assault that had been levied against her, and I mentioned it on stream, and she got so mad that she tried to sue me. Now I'm out of state. If she tries to sue me now, it's an even bigger pain in the ass. Also, the judge would just throw it out again, and she'd get labeled a vexatious litigant if she does that shit again. So, yeah, the fact that it's literally a 1 in a billion thing that this judge ended up seeing this and deciding, you know what? I'm gonna give this Illuminati lady the benefit of the doubt. Let's see about costing this young man a shitload of money in legal fees.
Please watch them. And here's the applicable standard on a 12b5 motion to dismiss. When considering a motion to dismiss for failure to state a claim, Colorado courts until recently applied the no set of facts standard, dismissing a complaint only if it appeared beyond a doubt that the plaintiff could prove no set of facts that would entitle him or her to relief. In 2016, the Colorado Supreme Court modified that standard by adding the requirement that the complaint state a plausible claim for relief. So the court went from this rigid, absolute, you can't prove anything, to you can't prove a plausible claim. So I think it's a little bit more favorable standard for the defendant. Under the Warren standard, the trial court still accepts all allegations in the complaint as true and views them in the light most favorable.
The fact is, by the word of the law, Oz Media is in the right. It's just a matter of how long is this boomer fucking judge going to let Illuminati drain Oz before, just dismissing this so Illuminati can start a new lawsuit to get that dismissed and then hopefully be labeled a vexatious litigant and be blocked from suing Oz again. Something about the American legal system you guys have to know is anyone can sue anyone else for anything. And in many cases, if you don't show up in court and defend yourself, you lose by default. So, yeah. When it comes to celebrities and people trying to sue celebrities for crazy shit, it's not an uncommon thing, although this is more of a stalker situation that happens too. Stalkers will sue and try to get restraining orders against the person they're stalking, so that person has to see them in court and they get to go be face-to-face with the person they're stalking. It's a big hole in our legal system.
To the plaintiff. However, facts pleaded as legal conclusions, i.e. boilerplate or conclusory allegations, such as those that merely repeat statutory language, are no longer entitled to the presumption that they are true. They must be supported by specific factual allegations sufficient to raise the right to relief above the speculative level. So there has to be some, at least kernel of possibility that the claims are entitled to relief by the court. The courts are fairly liberal in giving leeway to the plaintiffs when considering a motion to dismiss, because they don't want to just dismiss it out of hand if there's any chance, no matter how remote, that maybe some of it is true and can be proven. They want to see the evidence and not just go on the pleadings. So keep in mind now, as we go over these, that just because the judge might say something that's favorable to Blair and unfavorable to Oz or Felix the Kit Kat does not mean that the court thinks that she's right or that what she's saying is true. The court is merely saying that it's enough, in the court's opinion, to move on toward the discovery phase and eventually to trial so that the evidence can come into play more to show whether...
It's just such bullshit that this would even have to go to trial. It should have been thrown out. It should be thrown out before discovery. This judge is a fucking boomer. I guarantee you this judge is a fucking boomer.
Or not she's right, and whether or not what she says is true. So just keep that in mind. What we're going to read here in no way means that the judge believes Illuminati over the defendants. That's not what it means, okay? Simply asserting a legal conclusion bereft of any supporting factual allegations does not state a plausible claim for relief. A motion to dismiss for failure to state a claim is a challenge to the facial sufficiency of the complaint. It is directed at the four corners of the complaint, and accordingly, a court generally may consider only those matters stated in the complaint. However, Rule 12b provides that if additional matters outside the complaint are presented, the court has discretion to take those matters into consideration and convert the motion to a motion for summary judgment. So a motion for summary judgment is basically you're saying to the court has all the evidence and proof it needs. There's no need to go any further with this, judge. So basically they're saying, judge, we want the court to rule right now, based on everything that's been presented, that there's no merit to these claims at all. It's not necessary to go to trial. And I told you guys before too that it's very slim odds that the court is going to grant a motion for summary judgment unless it's really, really clear that this is a dog of a case and there's no way that the plaintiffs ever...
If you're wondering why it's probably like being given the benefit of the doubt by the judge, it's probably that Illuminati has such strong evidence of harm to her income from this. Because that's one of the 3 factors needed to confirm defamation or libel. And because one of those 3 is there's such strong evidence with her massive fall off and the amount of money she's lost from it, that's probably given the judge some pause to actually like give her a bit to like give her case, you know? Which fucking sucks, but you know, that like getting consequences on YouTube for being a piece of shit means that in court a judge is like, oh yeah, it does look like you're maybe entitled to some damages.
We're going to prove what they're stating in the complaint. After giving all parties reasonable opportunity to present material that would be relevant on a summary judgment motion, he's saying, I elect not to do so as the motion has not been fully briefed in that posture. So basically the judge is saying he doesn't believe that the motion to dismiss has enough material or enough evidence or enough information in it for him to be able to rule as a motion for summary judgment. And he goes on to say, if matters outside the complaint are submitted to the court but not considered, it is within the court's discretion whether or not to convert the motion to dismiss into one for summary judgment. So he goes on to say that in 2019, Colorado enacted the Anti-SLAPP statute to address lawsuits aimed at stifling or punishing the right to free speech, commonly known as strategic lawsuit against public participation, and to provide a procedural mechanism for the early consideration and dismissal of such lawsuits.
I don't think she lives in Colorado, though, anymore, right? I think she did at one point, but not anymore. So does Oz live in Colorado?
Colorado's anti-SLAPP statute is directly modeled after California's statute and also codifies pre-existing Colorado case law. The anti-SLAPP statute provides in pertinent part as follows. A cause of action against a person arising from any act of that person in furtherance of the person's right of petition or free speech under the United States Constitution or the state constitution in connection with a public issue is subject to a special motion to dismiss unless the court determines that the plaintiff has established that there is a reasonable likelihood that the plaintiff will prevail on the claim. Colorado follows California's two-step process for considering the special motion to dismiss under the anti-SLAPP statute, and Colorado's courts look to California cases for guidance on how to apply the statute. And we talked about this too, not only in the Illuminati case, but in the Janet and Lauren the Mortician case against the girlies, that they've also raised anti-SLAPP. And Georgia...
Listen, Biden has the opportunity to guarantee his victory in 2024 if he uses the presidential cancer ray in the best way possible, okay? Like, a guaranteed W.
Also is one of the states that looks to California for guidance to see how California interprets the law and to get guidance from that. First, the court determines whether the defendant has made a threshold showing that the conduct underlying the plaintiff's claim falls within the scope of the anti-SLAPP statute. That is, that the claim arises from an act in furtherance of the defendant's right of petition or free speech in connection with a public issue. An act in furtherance of a person's right of petition or free speech in connection with a public issue is defined to include 4 specific types of acts, of which the third is relevant here. Any written or oral statement or writing made in a place open to the public or a public forum in connection with an issue of public interest. If the trial court finds that the claim falls within the statute's scope, it then proceeds to the second step. It reviews the pleadings and affidavits and determines whether the plaintiff has established a reasonable likelihood of prevailing on the claim. If the court determines that there is not...
I feel like I should be wearing reading glasses, a robe, and, like, sipping on tea while I listen to this, honestly. Basically, to translate this into non-legalese, into normal English, it basically means that they're going to be looking... the anti-SLAPP laws that exist, they can't determine whether those apply until more evidence has been seen, is probably the claim. And because Illuminati has such a strong point with the whole, like, damages evidence, which he probably has a lot of, but probably not much of any other evidence, such as the claim that, like, A, the claims are false, or B, that Oz knowingly lied by repeating false claims. Neither of those two are true at all, so she could have no evidence of that, but she probably has very strong evidence that she had severe damages to her income, and that's probably why they're deciding that for it to be determined whether or not this anti-SLAPP law applies, they've got to bring it past, at least in discovery, maybe past that point, so more evidence is on the table, and the judge and... will there be a jury? Probably not in this kind of thing. Maybe not a jury. Most likely just a judge, so the judge can see more evidence. Well, there are anti-SLAPP laws to determine whether they apply. The judge seems to just want more info. You know, it's going to have to go to discovery, which means it's going to cost Oz more money.
Not a reasonable likelihood that the plaintiff will prevail in the claim, the court must grant the special anti-SLAPP motion to dismiss and award the defendant their attorney fees and costs. So now we move on to the first subject, the breach of contract claims that Blair made that Oz has asked the court to dismiss. The first claim for relief for breach.
If Oz loses this, not only does Oz have to pay for all the legal fees, but has to pay Illuminati in damages. Probably substantial ones for the amount that she lost because of people unsubbing from her. So it would be like the ultimate fucking terrible scenario. Is basically Oz becoming bankrupted because his abuser has money and power and can probably really bust out the crocodile tears in court. Or alligator tears? Are they crocodile tears or alligator tears?
Breach of contract alleges that Oz entered into an agreement with Pyramid, the Oz agreement, that required that he not use confidential information and or proprietary data for the benefit of any other person, corporation, or entity other than the employer during the term of employee's employment with employer or any time thereafter. Remember we talked about it.
She's going to try to get him on that contract, but even with this shitty lawyer, contracts like this get thrown out in court all the time. Contracts are not these set in stone things. Even prenups get thrown out in court. Judges are very open to circumstance and to context usually, if you're good enough at explaining it to them. And like there are plenty of fucked contracts that get thrown out in court.
Didn't put a reasonable time limit on this. At any time implies it's open-ended, it's forever. If Oz challenges the validity of this agreement, My guess is that a court would find it's not reasonable and would probably throw it out. But they haven't asked this court to do that. So, the court's not going to address whether it's valid or not. They're just going to look at the document and determine whether the conduct Blair complains of is actually a violation. And that he breached the agreement by using confidential proprietary information to defame or otherwise harm plaintiffs. Example of these breaches are set out in paragraphs 41 and 46 of the complaint. The complaint also references paragraphs 58, 59, 63, and 64, but these paragraphs refer to alleged breaches by other defendants. Oz contends that the breach of contract claim against him should be dismissed pursuant to Rule 12b-5 because it fails to set out with particularity his statements or other conduct that allegedly breached the agreement. The anti-SLAPP statute is not implicated by the claim. Paragraph 41 alleges that in April of 2023, Oz published a series of Twitter, now X, posts naming Blair as the aggressor and falsely claiming that she has a habit of starting fights. These posts also included Pyramid's confidential information. This is what Blair's claiming in the complaint. A link to a Twitter address follows, but clicking on the link does not produce the alleged post. So the court tried to use the link that she provided, and it was broken. Paragraph 46 alleges that in September 2023, Oz released a YouTube video titled Let's Talk, an update on Illuminati drama, which contained accusations in which Oz falsely accused plaintiffs of embezzlement. Nothing in either paragraph sets out.
How the fuck is the judge expected to sit and watch these, hour-and-a-half long YouTube videos? Illuminati, I worry, because, will it get to the point where the judge favors the person who's got the snappiest editing? Because these videos are going to be watched in court. They have to be because they're relevant. They're part of the evidence. So it's going to be the judge and everybody sitting there as these videos play on a projector or something. I worry that the judge is going to pay more attention to Illuminati with the little animated whatever and the zoomer slop editing as opposed to the arguments made by Oz in those videos. What are the odds this gets submitted for evidence? This video? No, not my video. Certainly not either. This video, my video, neither will be in evidence. No, that makes no sense.
The specifics as to how Oz purportedly used confidential proprietary information to defame or otherwise harm plaintiffs. And so
I could be a character witness for Oz Media.
There's a footnote here that the judge put in that I'm going to read because it's important. It says the court notes that in its order of January 15, 2024, authorizing a second amended complaint, the court instructed plaintiff that all statements on which they relied shall be set out verbatim in the complaint. That order was necessary because plaintiffs, in their previous iteration of their complaint, had failed to specifically set out the statements by defendants that they alleged were defamatory, making a substantive review of the complaint impossible. So the court's saying, we don't have enough information. You're not telling us what it is that's defamatory. And this is true of some of the other cases we've talked about, too, where the courts have basically scolded the plaintiffs for not putting out the specifics of the detail that is necessary to show why there's actually a cause of action here. Plaintiffs have again failed to comply. Amen. A link to what purports to be a Twitter thread, even a link that works, is not the same as a verbatim representation of the specific statements to which plaintiffs object. It leaves the parties and the court guessing, and accordingly, it violates the court's very direct and specific order. Finally, identifying the statements in their motion response is inadequate. The statement must be set out in the complaint. So they're saying you can't correct it after you failed to heed the court giving you these instructions more than once by putting out a response to the motion to dismiss and then putting some of it in there and saying, well, here it is. Their point is the complaint has to be complete in itself. Your whole position that you're putting forward of why something has wronged you and you're entitled to relief, the information has to be contained in the complaint so the court knows how to review it and how to analyze it. He goes on to say now, as noted above, under the Warren standard, boilerplate or conclusory allegations are no longer entitled to the presumption that they are true. They must be supported by specific factual allegations sufficient to raise the right to relief above the speculative level. No such specific factual allegations support this claim, and accordingly, it is dismissed. So the court has dismissed the breach of contract claim. So, I mean, technically now really the whole issue with the confidentiality agreement is kind of moot at this point because it's no longer going to play a role in this lawsuit.
Basically, Illuminati has lost, and it has been thrown out, the claim that she has made that Oz Media wasn't allowed to say what Oz Media said because of the contract that Oz Media signed, which could have either been the weakest or the strongest point against Oz, depending on how the judge felt. But since it's been thrown out, I honestly think this will likely go in Oz's favor after it gets to discovery. Something interesting is that Illuminati never served Wonder, so he's not getting sued, I guess. Dumb bitch, lol. It doesn't work that way. You don't have to serve someone for them to actually be getting sued. It doesn't really work that way. Otherwise, like, how could you sue someone whose address you don't know, right? Like, it's not exactly how it works.
As far as Oz is concerned, because the court said you didn't do what I told you to do, it's dismissed. Hallelujah. Thank you, Judge. Absolutely great. Now, we get on to the defamation claim.
That's a W,
Oz contends that the remaining claims against him, the third and fourth causes of action for defamation, should be dismissed pursuant to the Anti-SLAPP statute, or in the alternative, pursuant to Rule 12b-5 for failure to state a claim, which is what the court looked at when they dismissed the breach of contract claim, was 12b-5 for failure to state a claim. The statements identifying Claim 3 made in a YouTube video by Oz after the case was filed accused Blair of embezzlement. And we talked about that. He did not accuse her of embezzlement. He made it clear he wasn't sure what she said. He's saying she brought that up. Anyways, we've talked enough about that. The statements identified in Claim 4, made by Oz in the same YouTube video, accuse her of having placed him in a dependent, arguably coercive financial relationship with her. And then he goes on to analyze whether the anti-SLAPP statute applies here. And this is what he has to say, and I don't agree with him. The judge says, I find the anti-SLAPP statute does not apply because Oz cannot satisfy the threshold part of the analysis. While the parties agree that Oz's statements were made in a public forum, they were not made in connection with an issue of public interest. Now, we talked about public interest before. Oz's attorneys cited some case law. I disagree.
This is really bad, guys. Oh, no. Basically, what the judge said was that what Oz said was not of the public interest, which is very in favor of Illuminati. He's basically claiming the information that Oz Media made public, that her income was not of the public interest, as in claiming there was no good reason to have made it public. Oh no. Oh no. This fucking boomer piece of shit. Oz Media's gonna have to pay Illuminati. Dude. Oh god. The world is not a fair place, guys. Let that be a reminder. The world is a very unfair place. Ugh.
Agree with the judge here. I think it is a matter of public interest, and I'll talk a little bit more about it, but let's just continue and finish reading this, and then I'll talk about it. Neither of the statements identified in claims 3 or 4 were made in connection with an issue of public interest. While they were made in the public forum of the internet, and while Blair may or may not be a public figure, they arise out of a private dispute between Oz and Blair, and they solely address that private dispute as opposed to larger, more public issues. Now, and they cite this damn veterinary case that Blair cited to, which I think totally irrelevant and is not on point here. Here's the thing. Yes, correct. It was a private dispute. However, it became a public dispute. Both parties made it a public dispute when they went into excruciating detail on both sides, whether what they allege is true or not, about these issues and put it out there in a public forum. So, yes, it may be a private dispute, but it isn't anymore. It's now in the public, and the public is obviously very interested. I don't think the case law supports that conclusion, if that's what the judge is trying to say here. And I think for the reason I just stated that, yes, it may.
Dude, if it comes out this judge is like Illuminati's uncle's friend or something, I'm gonna goddamn lose it.
If originated as a private dispute, it's no longer a private dispute. Courts have kind of broadened that beyond. It's not just about like things going on in the community, issues of public interest. It's stuff that the public's interested in. And clearly the public's interested because it's garnered a lot of attention from the public. He goes on to say the statements by Oz expressed a personal grievance arising out of their personal relationship. They lack any nexus with any issue of public interest, and they do not contribute to any broader public discussion of any social or political issue of public interest.
Actual boomer. Actual boomer doesn't understand the internet. Fucking hell. And this might be precedent setting for those that don't know. In a really scary way, this could be precedent setting.
Thus, the anti-SLAPP statute does not apply. I don't agree with you, Judge. Again, that doesn't mean the judge is siding with Blair or thinks that she's right. He doesn't think that he has grounds to dismiss this count. It needs to proceed on the trial track. So he's not going to just toss it out at this stage. And so he goes on to analyze this. Because the anti-SLAPP statute does not apply, the court must assess whether the claims against Oz satisfy the Warren standard. So whether it can be dismissed for failure to state a claim instead of for anti-SLAPP. The traditional elements of defamation are a defamatory statement concerning another published to a third party with fault amounting to at least negligence on the part of the publisher, and either actionability of the statement irrespective of special damages or the existence of special damages to the plaintiff caused by the publication. Oz contends that plaintiffs must meet the enhanced actual malice standard set out in New York Times v. Sullivan because the challenge statements relate to a public figure. That standard also applies if the statements relate to a matter of public concern, but as discussed above, they do not, in his opinion. However, I will not apply the actual malice standard in this posture because the evidence as to whether Blair is a public figure consists, for the most part, of matters outside the four corners of the complaint. I'm not quite understanding why he's saying this. So basically he's saying, well, it wasn't argued in the complaint that she's a public figure. That's something the court has to decide based on an analysis of the whole situation. And he's claiming, oh, it's not in the four corners of the complaint, so we can't.
The judge is claiming she's not a public figure because he doesn't understand the internet. The judge doesn't understand the internet and doesn't understand that YouTubers are public figures and isn't going to apply that standard to her. She's going to get the treatment of like a normal everyday citizen who's been potentially maligned with slander, who has massive damages. How is this person with over 1 million subs on YouTube not a public figure? This judge is a mega dipshit. I mean, slapsuits exist. There's a term for it for a reason. They work. They really, really work. Powerful people have kept those that they've victimized down for a long time using them. The American legal system is brutally flawed.
Can't decide whether she's a public figure. I don't know. I think it's absurd. And I decline to convert the motion into a motion for summary judgment. Thus, for the purpose of this motion, I will apply the traditional elements of a defamation claim as set out above. Oz's challenge focuses first on the first element of the claims, namely whether his statements were defamatory. To determine whether a statement is defamatory, the courts employ a two-part test. A court must determine whether the statement consists or implies a verifiable fact about the plaintiff. And second, whether the statement reasonably is susceptible to being understood as an assertion of actual fact. Claims 3 and 4 meet this standard. The statements made in both claims contain or imply verifiable, I guess he's talking about when the evidence is presented and through discovery, whether or not it can be proven that she embezzled. So apparently there's going to be a lot of financial documents coming from Blair's side in discovery. So I hope she's prepared to, shine a light on her financial dealings. Claims 3 and 4 meet this standard. The statements made in both claims contain or imply verifiable facts about Blair, that she committed the crime of embezzlement and that she placed Oz in a dependent, coercive financial relationship. Oz contends next that plaintiffs have failed to sufficiently prove special damages in connection with Claim 4, defamation per quad, contending that the drop in revenue alleged in that claim occurred before rather than after the contested statement. That is, in fact, what the complaint alleges. I do not consider the additional materials that Oz submits in connection with this argument. Claim 4 is based on a September 16, 2023 video, the Let's Talk video, but it then alleges that Oz's statement caused special damages as evidenced by the fact that plaintiff's revenue from videos dropped by more than 95% in the period September 16, 2022 to October 1st, 2022 from
What I tell you, the thing that would have immediately made the judge lean with a bias in favor of Blair is that massive 95% drop in revenue. Because the judge doesn't care where you make your money. He may not understand what ad revenue is, but what he does know are numbers from bank statements that you're under oath saying this is how much you make. And they see that drop and it's like, holy fuck, it does seem like something caused you to lose 95% of your income, and then there's the whole like, well, you're not really a public figure, so you're just some private citizen who's lost 95% of your income after this Oz media spoke about things that are not of the public interest about you. Oh, poor young lady. This is scary. I'm not gonna lie, guys. This is scary. I highly recommend you guys go to Oz Media's channel when Oz Media is live, especially doing fundraising streams for the legal fund. Go drop a nice dono. Go send like at least $5. I could use donos too, but Oz Media is in a tight fucking spot. So please, if you've got the money to spare, go toss a coin to Oz Media. It would be really helpful. I'm gonna let it play for just a little while longer, and then I think we're gonna wrap up this segment.
47,665 down to $1,312 during the same period a year later. Thus, as alleged, that drop in revenue took place in the year before rather than after the Let's Talk video. As a result, Claim 4 fails to plausibly allege the required element of special damages. Accordingly, I find that Claim 3 satisfies the warrant standard, but Claim 4 does not. So, basically, he's dismissing the claim for special damage. She's comparing a whole year's worth of revenue, most of that occurring before Oz's video came out.
Claim,
that doesn't
though, for special
show
damages.
Me that
That's
your
good.
revenue dropped precipitously right after he posted his video. You're saying that it dropped over a 1-year period. I note finally the complaint is defectively pleaded in that it fails to set out each...
Oh, okay. Okay, you know what? The boomer judge actually was a benefit for one point of this, and that's that the judge doesn't recognize that a thing happens and has months of effect over the course of time on YouTube. The judge says, oh, how could Oz Media have made this video, and then over 6 months your revenue drops? How could that have been from the video? And it's like, we all know, yeah, well, it was because of the stuff from that video in a way. I mean, people continue to repeat it, and it went around, but, like, the judge is such a boomer, he doesn't understand that, like, a big drama happening means months and months and months, maybe years of online blowback. And so the judge doesn't recognize that as actual damages caused by Oz there. That's crazy. Hey, well, at least there's a W there for boomer judge, you know? Accidental W.
Alleged defamatory statement in the form of a separate claim. So the judge wanted to see count 1 defamation and then a statement, count 2 defamation and then a statement, rather than lumping them all together. Only those that have been separately set out in claims 3 and 4 will be considered to be claims for defamation. Those that have not been set out in that way will not be treated as such. So he's not going to consider any other allegedly defamatory statements other than the embezzlement allegation and the one about the coercive financial relationship. I mean, that's a partial win for Oz because that narrows it down. The 9th claim for relief. Oz objects to plaintiff's 9th claim for relief for computer fraud. Okay, now this is sticky. This is where I get really annoyed with the judge, okay? Remember we talked about how the judge had ordered her to file a second amended complaint, basically to give the specifics that the court asked for and to spell it out so the court could clearly see what she was alleging was defamatory. And she didn't do that. And the court has even said that she didn't do that. But we talked about how Blair's team took the opportunity in filing this second amended complaint to add in a claim for computer fraud. And I had said that in my opinion, when I read the court's order, it is clear to me that what the court's inferring is you need to file a second amended complaint because you need to give us more detailed information about what you're alleging is defamatory here. And Blair's team argued that we're throwing this in because the judge just said file a second amended complaint and didn't say we couldn't. And to me, that seemed like a ridiculous argument. But this is now what the court has to say, and I'm really disgusted with the judge. So it says, Oz objects to plaintiff's 9th claim for relief for computer fraud on the ground that amendment to include this claim was not approved by the court. Defendant responds that the court's order of January 15, 2024 authorized the second amended complaint without restricting the claims that could be alleged in it. I'm not sure, but it appears to me that the judge, this is a typo, and that it should say plaintiff responds that the court's order authorized the second amended complaint without restricting the claims that could be alleged in it, because that's what Blair's team argued. So I think that's just a typo. The judge says, I agree the order was not clear as to the scope of the second amended complaint that it authorized. While the order was clearly issued in response to defects in the defamation claims, it did not expressly limit amendments to those claims. Before I read the rest of this, the other thing that we have to remember is not only did she not comply with the court's order in the second amended complaint to give the detail the court wanted, but she filed it a week late and didn't get the court's permission. And the judge had said that it had to be filed on a certain date or he would grant the motion to dismiss. And he didn't do that. And she didn't ask permission to file it late. She just filed it late. So that annoys me too, that he's giving her leeway. So this is the rest of what he says. I will resolve the issue with an eye to practicalities. No objection has been raised to the 9th claim for relief other than the authorization issue. Were the court to require a motion to amend in order to address this new claim, it would only delay the long delayed case further. Now, why would the court allow them to file a motion to amend the complaint? Again, I thought...
Oh, guys, I don't know about this. This is looking bad. This is looking bad. There are like 5 billion videos on this topic, not a public interest. Lol. Can you guys see why I was so tilted when I found this out? I get it, Warpaint, when I get why you sent it. I'm worried, guys. Please, go support Oz Media. Links to both this channel and Oz Media down below in the description. Assuming my editor did that. Hopefully Ethan gets that done. But hey, if you enjoyed this video despite the grim subject matter, please consider dropping a like and commenting down below, subscribing, and ringing the bell icon. All these things boost my channel and the algorithm a lot, and for those that don't know, my channel's been growing a lot lately, so thank you to those of you guys who have been doing that, because it really is having an effect. So keep it up. I really appreciate it, guys. Thank you for the likes, the comments, the subs, all that good stuff. I really do appreciate it. Follow my social medias, linked down below. Join my free fan Discord server, which I mentioned it's free because people ask if it costs money. My Discord server down below. It is the main hub of my fan base. We do watch parties, call-in streams, game events, all sorts of cool stuff there, including a watch party right after this very stream, after this segment. And if you want to support me directly, financially, consider donating, subscribing, or gifting a sub on my website, xanderhall.com/live, or supporting me through YouTube, Twitch, Streamlabs, Stream Elements, Patreon, or buying my merch to the Streamlabs link down below. With all that said, thank you so much for watching, and have a good one.